Good afternoon. My name is Tlou, Phihlela. I'm the Supervisory Legal Practitioner for Civil in Benoni local office. Today is the 4th day of the National Wills Week. Now, during this week, you can visit your nearest local Legal Aid South Africa office and have a basic will drafted for you for free. Today we're going to discuss marriages, the different marital regimes, that is the different types of marriages that you can enter into in South Africa. We're also going to discuss how you can contest the will, where a will is made and you are unhappy with what is contained in the will. We're also going to focus in particular on children, especially where children were not mentioned in a will. We're talking minor children, whether there's any recourse in terms of the law for them. And we are also going to just reiterate the importance of having a will and what the legal consequences would be if you die without leaving a will. So, if anyone has questions during this live broadcast, you can leave them in the comments below, in the comment section below, and we'll surely take our time to answer them. So, let's get into it. Marriages. Deciding to get married is one of the most important decisions you can make for yourself because it affects your status. It also affects a lot of areas of your life, not let alone your estate. So when deciding to get married, it's always advisable to first seek legal advice, just so that you can get a proper explanation of what the different types of marriages entail and their consequences. For instance, let's say if you are a business person and you are married to somebody who works a 9-to-5 job, it's always preferable that that marriage be a marriage that we call an out of community of property. So in South Africa, we have a marriage in community of property. This is almost the default one that everybody knows about, where what's yours is mine and what's mine is yours. So that's the most common one. We have a marriage out of community of property. This is the type of marriage, it's the opposite of a marriage in community of property. It's what's yours is yours, what's mine is mine. They are commonly referred to as an out and out marriage out of community of property. Then we have a marriage which is a marriage out of community of property with accrual. Now this is more like a hybrid or a compromise between the two, being out and in community, in that during the subsistence of the marriage, each one of you handles their estates independently, and it is only upon divorce that we now see whose estate has grown the biggest, and they will then have to pay over the difference to their spouse. So essentially it tries to even out even the scales. So it's quite important, depending on the type of work that you do, depending on your future ambitions and aspirations professionally and otherwise, to actually consider the implications of each type of marriage. So for people in business, commonly they will prefer the out and out type, because when making decisions you don't have to seek permission from your spouse to sign contracts and those kind of things. So a marriage in community is one where essentially we are equal partners. if you are making any decision that's going to affect the value of our estate, then you have to ask for my permission. So marriages, it is also important for the purpose of what we call estate planning, because there are certain implications. If you are married in community of property and you die without leaving a will, then we say that your estate devolves interstate. There is a piece of legislation, we call it the Interstate Succession Act. Essentially, you are leaving government to now decide on how your estate has to be administered. So when you're married in community of property and you don't leave a will, the chances are that almost 75% of your estate will go to your spouse, and your children will be left to share about 25% of it. For the following reasons. One, your spouse will get 50% by virtue of the marriage in community of property, and then she'll be entitled to a child's share, which is equivalent to 250,000 or any amount, whichever is greater, depending on the size of the estate. So this has very far-reaching implications for you, especially if maybe you are a person who has been married before and you've got other children that you want to take care of. So you're going to find yourself in a situation where they are not catered for, because the bulk of your estate would have gone to your spouse. So even if you are married, it's always advisable to have a will. If you are married in community, you can have a joint will where both of you decide what should happen to your estate in case of one of you dying first, and also catering for your dependents. Or you can have separate wills where each of you is dealing with their 50% share. There is nothing in law that prevents you from dealing with that share that is coming to you. The only thing is you can't deal with the share that doesn't belong to you. You can't say your spouse mustn't get anything from the house or whatever, because you are not on a good note. Yeah, so marriages in community of out of community of property, on the other hand, if it's out and out, for the most part, it says that your estates are separate, so your spouse will not be entitled by virtue of operation of the law to half of your estate. But then there is a catch. If you die without leaving a will, essentially the Interstate Succession Act will apply. So this means that your spouse will, even though you had agreed to run your affairs separately, they will eventually get a share in your deceased estate. They will eventually get a share in your deceased estate. So those are some of the issues that we always recommend, that when you have a substantial, if you have something important that you feel must go to a specific person upon your death, it's always advisable to have a will. We're not talking just money. You need to have a lot of money, because people think wills are for the rich, when in truth a will is important because it helps to create certainty and avoid disputes. People having to argue over your things when you are no longer there. Instead of resting in peace, you are turning in your grave because somebody is fighting over something that was not meant for them. So it gives you a final say in how your things should be distributed. So it's very important to have a will. Let's move on to contesting a will. Unfortunately, at times it happens that the will, maybe you have been excluded from benefiting from a will, but because of the circumstances, you are unhappy with that decision, because maybe you know that something wasn't right. You know that your parent or your spouse or whoever will not have done that to you, you know. So the law does give you an opportunity to contest the will. Now, the grounds upon which you can contest the will, one, it's mental capacity, where you're saying that this person did not have the mental capacity at the time to appreciate the act of making a will, or also the implications of that decision. The second one, it's where you are saying there has been influence. This person was influenced unduly so to exclude me from the will. Or maybe they were threatened and forced to sign the will, or somebody took advantage of them on their deathbed and made them sign. You know, but each one of it will depend on the specific circumstance of each case. So the law does allow you to contest the will if you are unhappy with it. Now, when it comes to minor children, it's a bit of a different story. As a parent, in terms of South African law, we have something we call freedom of testation, which essentially means that you can do a will and dispose of your property as you wish. The only conditions are that it must not be against public policy or morals, and it must not be unlawful. It mustn't contain unlawful provisions. It may happen, the question that I often encounter is what happens to a will where there is a minor child and maybe the parent did not maybe update their will before they were born, and now the will does not give them anything. It does not leave them anything. What do you do? What happens? What happens to the minor child in those circumstances? I'm going to refer you to 3 pieces of legislation that can assist in those circumstances. We have the Children's Act. We have the Administration of Deceased Estates Act. And we also have the Maintenance Act. So with the Administration of Deceased Estates Act, when that will comes through, you then lodge a notice of objection with the master to say that you are challenging the will, wherein you will set out the grounds upon which you are challenging the will. As a minor child, maybe it will be that the will did not make sufficient provision for you, or you were excluded. Remember, parents have a duty of support for their children. It's not something that you can run away from by making a will and saying, no, I'm not going to give him anything. Even if you don't leave something for the minor child will have a claim against the estate. And this claim will arise also in terms of the Maintenance Act, where your estate will have to provide support to the minor child. And where people are married, we have the Maintenance of Surviving Spouses Act, which also deals with the maintenance of surviving spouses, where otherwise one spouse left them out without any provisions in their will and so on. We also have the Children's Act, and the standard that is advocated there is the best interest of the child, which has been constitutionally interpreted to be to trump most provisions, especially when it comes to the issue of the wills, because then we look at what is in the best interest of this minor child. Moving on, we are going to discuss now what happens. I think we've already touched on it, on what happens if you die without leaving a will. And that is where the Interstate Succession Act comes into being. And in terms of that act, we look at, firstly, the person to benefit will be your spouse, if you are married. If not, then it will be your your descendants by blood or by marriage. It's a bit of an involved exercise, so I will not burden you with the details too much, except it is not advisable to die without leaving a will. It's important, especially in this Wills Week, to just take the opportunity, come to one of our offices. We have a national footprint in all the provinces. Our offices, you can find them everywhere. Every court, we have a representative there. So come to us, let us assist you to draft a will, to make sure that your final wishes are given effect to. We are available. If anyone has any questions, we are willing to assist.
Okay, so we have a question here from Sizwe. He says, how does a male in a polygamous marriage draft their will? Do they draft a joint will with all the spouses, or how?
Thank you, Sizwe, for that wonderful and interesting question. What I would recommend, it's better to have a joint will, because that way you'll create certainty and you'll ensure that the wishes of each one of you are taken into consideration. Obviously, you want to make provision for all the children of that polygamous marriage, so that everybody is taken care of. And you also perhaps want to maintain cooperation amongst the surviving spouses, so that everybody knows what they expect and what is due to them in the event of death, because then that will avoid a lot of conflicts developing later when you have passed on and people are fighting over your body or fighting over things that you have left behind and so on. So I would say it's better to sit down with all of them and try as much as possible to come up with an arrangement with a will. Remember, a will, it's you communicating from basically beyond the grave. So there are no complicated terminologies that are applicable. There are no magic words. You simply you write your wishes down in simple and plain language, trying to explain them exactly what should happen in these circumstances. So think about it in that way. It shouldn't be something complicated, and that's where we'll come in to assist you with the legalities and to also advise you whether those provisions that you have included there are valid or invalid in law, or what the potential would be, and so on. I do hope that covers your question.
Thank you. We have another question from Walid. If one sibling has a will of a deceased mother and has kept it quiet all these years, what will happen to them?
Thank you, Walid. Essentially, when the testator or testatrix dies, the person making a will dies, remember you have to present that will to the master, so that the master can then give effect to what is contained in the will. So it's not so much a question of validity of that will that is in question. The fact that the other sibling has retained the will somewhere and has not disclosed it, that's one thing. It doesn't affect the legality of the will, unless you guys are saying that somehow there's been the sibling has influenced your mother unduly, or has forced or tricked her into signing a document, or you are suggesting that your mother's mental capacity at the time was not, she lacked the necessary mental capacity. Then you are able to challenge that will before a court of law. But it's always better to first try and mount a challenge at the master's office at that stage, contest the will at that stage, and then if you are unhappy with the decision of the master, you then take it up on review in the High Court. So I hope that answers the question from Walid.
If you were to take it up on review at the High Court, would you need a lawyer for that?
Most definitely. It's a High Court litigation. It's a technical field, and there are also important considerations to have in mind, such as costs, because costs in the High Court can be very, very, very high, unfortunately. So you need to make that determination at the beginning. Litigation should always be a last resort. It should never be that because you are annoyed with somebody, you're going to run to court. We only go to courts when talking has failed and we have tried everything to reason, and now there's no alternative because our rights are being infringed and whatever the case might be. So going to court should be a last resort, and you should always get proper legal advice. Try and obtain a legal opinion in advance so that you are aware of the prospects. If they are saying it's a 50-50 chance, then you'll be able to say whether it's worth the risk or not. You'll compare the benefit that's going to come from litigation vis-a-vis the costs that are involved to get you there. I do hope that answers the question.
Okay, we have another question from Bonang. They say, can you please assist with the difference between WP 1002, where you write all your beneficiaries and indicate who must get this and percentage thereof, and what happens when you die unmarried with kids without a will? So it's 2 questions.
So you want to know how to complete the W11P form?
Mm-hmm. What is the difference between, it seems the question is, what is the difference between that and a will? Are they the same?
No. Mm-hmm. They are not the same. Remember, a will is intentional. Where you are saying that form essentially it's for administration purposes, where they want to know what are the assets that are involved, who are the beneficiaries, or people who stand to benefit from the estate. So that one is for the purpose of them determining how many people are involved or should be involved in the administration of this estate, so that you can then go and get consents from each of them in order as to who has to be the executor and so on and so forth. So a will, it's different in the sense that it specifically deals with, it's by the person, the testator, we call them the testator or testatrix. The person making the will is basically outlining their intentions as to what needs to happen. So it essentially, it also, it takes place of many things, because now there's less worry as to who has to benefit from that will, because the will would have been specific. If I say I leave everything to my children, then all my biological children and adopted ones would then be the ones to benefit from my estate. Whoever can prove that they are my child then will then benefit. Alternatively, I can specify the names and say I leave to so and so and so and so and so and so, meaning that everyone who is not mentioned in that will is then excluded, because I've been specific in terms of who I want to leave the benefits from my estate to, and so on and so forth. So I do hope that it does assist, because usually when you report an estate and then there's no will, then that's where you have to then complete all those forms. Normally in the will, we include a clause where we nominate one of the beneficiaries as an executor. So so that when the will is presented to the master, he can issue a letter of authority or executorship in the name of that person that is nominated. It's only when they are not nominated that we'll then have to complete those forms and indicate who are the children, so that they can then be called and gathered around, and they can decide who amongst them will be the executor, whether all of them should be included in the letters of authority or executorship, and so on.
Right. We have a follow-up comment from Walid. They say she traveled the country, so I assume the deceased mother, traveled the country and left a will and gave it to my older brother to keep. And now he wants to sell the house while I don't have a place to live.
Look, what I would say, Walid, is it's important to also know what the will provides for and what is contained in that will. It will be difficult to give you advice in a vacuum without knowing the specifics in terms of what the will provides, and also what your intentions are with regard to that will. Whether one, you want to challenge the will as being invalid, or whether you are just saying I've been excluded and I'm unhappy with the decision to sell the house, or even whether you have been included in the will, but one, your brother wants to sell and you are saying, no, we can't sell because I will have nowhere to go. So there's different layers to your questions. What I would recommend, you can phone our advice line. It's a toll-free number. It's 0800 or 0800 110 110. This is weekdays between 7 a.m. and 5 p.m. You can always send a please call me to 079 835 7179. So send a please call me, we phone you back, and then we can discuss. And depending on where you are, we'll then send you to your nearest office. If it's a matter that now requires us to get involved fully and take full instructions and so on, then we'll then point you in the right direction as to which office to go to. There you can then sit down with one of our competent legal practitioners and get assistance that you need. All the best, Walid.
Sizwe had made a note that their network cut, so they didn't get the response, but they've seen the typed up response.
Okay.
So I think that's in order. We do have another question that's come through as anonymous in our inbox, and it's a bit more about procedure.
Okay.
But if for instance, if my parents draft a will and I'm still a minor child, is it okay if they give that will to me to keep? What is kind of the preferred actions around that? Can I even know what's in the will if I'm a minor child?
Yeah, look, once the will has been drafted, we always recommend that you keep it in a safe place among your important documents, but not to forget to tell somebody of the existence of that will, preferably the beneficiary. Not for them to know what is in the will, because maybe it might encourage them to hasten your departure from this world, but just so that they know where to go when something happens. I seem to remember in the past, the master also, you can go and file the will with them. I don't know if they still accept filing and safekeeping, or only when a death has occurred. But what I would recommend is, if you have possession of that will, keep it in a very safe place. Keep it in a very safe place amongst your important things. And just be sure to leave a note to someone to say, if something happens to me, there is this envelope somewhere, find it, it has everything that you need. That is always the preferred option. If you have a safe, even better. But there is nothing wrong with you having insight into the will. If your parents allow you to know that you are the one beneficiary, it doesn't invalidate. The only concern would be where you were also a witness in that will while you are a beneficiary, because that might affect the legality of the will, where there will be allegations of undue influence or even duress or those kind of things. But the law does say that does provide that if you are still going to benefit by intestate succession, then that disqualification basically doesn't apply. So over and above, you can always go to court and have a will declared valid or invalid or whatever the case might be. So keep your will safe. And one important thing that I forgot to mention when we spoke about marriages, it often happens that you are married, then you divorce, and then you forget to amend your will. Now the law says, if your spouse, if you die within 3 months following the divorce, then we are going to administer your estate as if your spouse had died first. But after a period of 3 months, we are going to give effect to that will. It doesn't matter that you forgot to amend the will and so on. So you only have 3 months within which to amend the will or to change your will or to revoke it clearly, because you need to, you can revoke a will and not have a will. We normally include a revocation clause in any subsequent will that you make to say, from this date forward, all my previous wills are revoked. This is my last will and testament. So it's important also whenever there is a change in your life, whenever there is an event in your life, an important event, the birth of a child, death, marriage, maybe you are getting, you are moving to a different place, whatever is important. Whenever there's an event in your life, always review your will. Review your will. It's not to say you need to change it, but make it a habit to annually just re-look at what is in that will, because most people, the danger is they make a will and then they forget about it completely. And it only emerges when the person has died and now we are trying to give effect to what is in the will. Maybe some things you mentioned in there no longer exist. I left my car and now I no longer have that car. It creates a bit of confusion when the intended purpose of a will is to create certainty. So watch out for that. So I'm still here to answer your questions.
We haven't had more coming in, but the anonymous question poser did say thank you.
Okay. No, if there are no questions, it's a good thing. Then it means everybody understands and the presentation was clear.
Yes.
So it's quite a good thing.
And they still have the rest of today.
Yes.
A couple of hours and tomorrow.
Yes.
To have a basic will drafted for free.
Yeah. So thank you all for joining us today. If you have any further questions on this topic, you can call our toll-free line, the Legal Aid Advice line, that is 0800 110 110. I repeat, it's 0800 110 110. we are open weekdays from 7 a.m. to 5 p.m. So it's Monday to Friday, 7 a.m. to 5 a.m. You can always send us a please call me if you don't have airtime. You know, times are hard. If you are experiencing those challenges, or just for your convenience, send us a call me on 079 835 7179. That's 079 835 7179. You can also visit our website. We are on www.legal hyphen, dash. You must put a hyphen, legal-aid.co.za. That's www.legal-aid.co.za. If you forget that hyphen, it's going to take you to a place we don't know. So you want to be lost on the net. So it's important to remember that hyphen. We are also on Facebook, of course. It's Legal Aid A1.
Legal Aid SA1.
SA1, sorry. Legal Aid SA1. We are on Twitter, now X. It's called X these days. Yeah, also Legal Aid SA1. So we are on social media. We move with the times. You can find us at your convenience, and we are always willing and ready to help, to assist where we can. So thank you for the time.
We have one question that's just slipped in.
Questions are good.
From Kitso. It is something you've discussed, so just a quick rehash. What are the procedures to follow if you wish to contest a will?
Okay. Contesting a will, the first one would be to file an objection with the master. You file a notice of objection with the master, and you indicate on what grounds you are contesting a will. Then the master will call a hearing. If the grounds are, if he finds in your favor, then he will declare that will invalid or whatever the case might be. And then whoever is not happy with the outcome of that can then approach the High Court. Unfortunately, you can only approach a High Court when an issue of this nature is involved. Magistrates Court, regional courts do not have jurisdiction. So only the High Court can assist you. Secondly, you can also bring an application in the High Court for a declaratory order, where you are asking the court to declare the will to be invalid. And that will be in terms of Section 2A of the Wills Act. So you bring an application in the High Court on notice of motion, supported by affidavits, where you are saying, for whatever reasons, the grounds that I put forward, which are the common ones, has to do with mental capacity, and also has to do with anything that affects the freedom of testation, the free will of the person making the will. That is duress, they were forced, they were unduly influenced, maybe there was fraud, their signature was forged or faked, or whatever the case might be. So the grounds are many, and we can't discuss all of them. We can't think of all of them. It will depend on the specific circumstance of your case. But that is simply the procedure that is involved.
And where do you find master's offices?
Master's offices are also spread out throughout the country. They are usually next to the Department of Justice in your town. So if you go to the Department of Justice, you can also, I think there's also, if you go to the website of the Department of Justice and Constitutional Development, you will get the list of the names, their phone numbers, the offices. It will tell you who are the master and the assistant masters involved, and the offices that they are at, and so on. So that information is freely available online. Just go to the website of the Department of Justice, or just go on Google and Google Master's Offices or Master of the High Court, South Africa. Then it will give you a list of all of them. So thanks to the advent of age of information, everything is available at your fingertips.
We've had one more question come in, so it's from Tlou.
Okay.
And let me hold on. Kitso has quickly responded. Let me just address that first. Kitso says, does notice of objection automatically mean that the will is invalid once the Master's Office has confirmed?
Look, obviously it's not an automatic thing. Remember, the master has to accept the will. He's the one responsible for deceased estates in the whole country. So whenever there's a will, it first gets delivered to the master. The master has the powers to say that he will not accept the will because to him it's invalid. But thankfully that his decision is not final. Hence, you are able to approach the High Court and set aside his decision. But for all intents and purposes, if the decision of the master is that the will is invalid, that means he is not going to give effect to that will. So that says that the will in the eyes of the master is invalid. So you cannot now enforce that will with the office of the master. If there's no other will that is presented, then he's going to administer that estate as if there is no will. So once the master says, no, this will is not valid, then the only recourse for you is to then approach the High Court and challenge the decision of the master.
Then we have another question that's come in from Tlou. They say, not related, but can you advise on decolonizing insolvency law in South Africa, focusing on sequestration? Is this perhaps a law student who's trying to get...
Yeah, you're trying to get assistance with an assignment or a thesis. Look, unfortunately, that one is unrelated to the subject matter that we're discussing.
I thought so.
And it involves political legal theory involved in there. Because then if we are decolonizing and we have to give effect to the advent of the constitution and, so unfortunately we have chosen today to concentrate on wills, given that it's the Wills Week.
Yes, and they can find this information if they do their research.
Of course.
Excellent. Okay, thank you. They included a little skull emoji, so I think they realized it was a bit of a stretch. Right, so those are all the questions. So okay. I think if you're happy to close, Tlou, you're welcome to.
Thank you for having us. Thank you for the questions. For all of you who took the time to listen, to participate, we thank you. As they say, motho ke motho ka batho. Re a leboga. Thank you.